Welcome to Chicago's Legal Latte, presented by Lavelle Law. In each episode of the series, the attorneys of Lavelle Law will share news, updates, and information on legal topics that impact individuals and small businesses. Your questions and suggestions are always welcome at info@lavellelaw.com. Welcome back to Chicago's Legal Latte. Hi, everyone. I'm Jim Mitchell, and we move our podcast series into a new location today. We're going to sit around a table here and have some discussions. Now, as you know, on our podcast series, we frequently reach into the headlines, but it's usually new legal cases, rulings, laws that may be impacting individuals and businesses. Today, we're going right to the biggest headline there has been in a long time. Of course, Taylor Swift's engagement to Travis Kelce. We're going to have a fun conversation today. I'm joined by two of the partners from Lavelle Law. Got Joel Zalski, who is here, and Christina Buckthal-Alkes, who has been with us many times before. First of all, thanks for being here, guys. Great to see you again.
Thanks, Jim.
So our conversation, we're going to talk about this engagement, which has got everyone talking, of course. It's the latest news. But there are some factors in it that are relevant to people who are interested in the law. And while we will talk about Illinois law here, this is not meant as advice or legal guidance for anyone, but we are going to talk about some of the things that might be happening in a case like this. So let's talk about what people should be doing when they look at getting married. We're going to talk about prenuptial, and I'm going to use that term, Joe. I'll start with you. Prenup, premarital, what's the right term to use here?
Both those statements are correct. Prenuptial or premarital are both the same. Basically, it's just a contracted agreement between parties before they marry about what will happen to their assets that they've acquired prior to the marriage and during the marriage, and their income as well as debts and things of that nature.
So it's we hear about it. We hear about it in celebrity cases. Do average people have prenups?
Yeah, most people, in many cases, they should have prenuptial agreements if they have certain assets that they've acquired prior to their marriage that are fairly substantial, like second marriages, for example. It's a very, very important time to do that when you have family members and things of that nature. If there's inheritances, things of that sort. If there's a business involved, you've got a family business in those type of situations, it's very important to consider prenuptial because your agreement that you make with your future spouse may have some effect as it relates to the asset or the business that we're talking about that might be family related. So there's a number of different areas that the prenuptial agreement would be helpful to people, even without large asset bases such as Kelce and Swift here.
And Chrissy, we're going to kind of play this out today a little bit, but kind of describe the process of getting a prenup put together. What takes place?
Thanks for asking. The most important part of a prenuptial agreement is a disclosure of all the assets. The document isn't any good if the parties don't disclose the assets that they have, because if that's the case, the parties really don't know what they've waived their right in the document to.
Okay.
So a total disclosure of assets is the most important first step. And then, the attorneys typically can take it from there and negotiate. What our average client needs to make sure that they know is that both parties should be represented by an attorney. And they should make sure that the prenuptial agreement is not signed the day before the marriage. That's a big bright line that causes judges to raise their eyebrows. It's considered to be somewhat coercive at that point. If parties sign well before the marriage and they make a total disclosure of their assets, we're on good, and they're both represented by attorneys. We're on good ground.
All right. So I'm going to ask you the easiest question all day. We're talking about, as I said, we're not representing either of these parties, but is there any chance these two would not have a prenuptial?
I like to think that we're all very optimistic about love, but I think of this more as an estate planning tool than a divorce tool. We really, people need to know where their assets are going to. I'd like to think that Ms. Swift, my client, has a lot of people relying upon her, and she doesn't want those assets to be up in the air or in dispute or in litigation because it could be expensive, time-consuming, and emotionally draining. And the people who are relying on her to have those assets, need some security as well.
And before we get into the fun, one last question for you, Joe. You mentioned second marriages, and that's something I thought about. Young couple in their early 20s, they may not have a lot of assets, but people who are maybe in their 50s, 60s, I know people are remarrying later in life. Right. They've got kids, inheritances. Right. Is this a much bigger deal for someone who's...
It is in a second marriage, especially where there are assets that are related. In most situations, retirement accounts are very big, IRAs, things of that nature. which may be substantial in value and be accumulated for a long period of time before the second marriage. So many clients want to protect that interest because it was all earned prior to the marriage, and they make other arrangements for their current spouse through a prenuptial agreement. That can be included in the agreement when you talk about distribution of assets in the event of a divorce. So it's very helpful in second marriages, especially where you have working people who've got accumulated assets over time, including real estate, things of that nature, businesses, all those type of things. So yeah, it's important. And then the inheritance part also.
Right.
Sometimes families are combined. A second marriage can have more children, okay? And a party may want to prepare and have their assets set aside for their family members, their specific family members, which could be affected in the event of a divorce without a prenuptial agreement.
Interesting. All right. So let's get into this. Christy, we're going to turn to you. Taylor Swift is your client.
That's right.
Start us off.
Okay. So in the event of a dissolution, what we're requesting is that my client, Ms. Swift, retain 100% of her recorded assets, her royalties, and all, like her songbook, essentially. That was hers long before this relationship started. It should remain hers during the marriage. It should remain hers 100% after the marriage. Also asking that that any royalties that are paid out belong solely to her from the music, and any tour income that she earned also remains solely hers. She has a substantial real estate portfolio, $110 million in real estate. And so, Joe, we're asking that that all those properties remain hers. And in the event of the parties are residing in one marital residence, we would be willing to give Mr. Kelsey 50% of the appreciation in that marital residence that transpires during the course of the marriage, but none of the original value. So really the 50% appreciation. And I think that, Ms. Swift would be looking at paying Mr. Kelsey a payout at the end of the divorce or the end of the marriage equivalent to $1 million per year for years that they were married.
Mm-hmm.
And I'm just going to jump in. I want to make something clear. You talked about assets that Ms. Swift has now.
Yes.
You also mentioned future earnings, though. That's part of these discussions.
Yes.
Right. And I think that Joe's probably better to speak to that than I am. But the point is that they're the value of these assets now.
Right.
Those assets should belong entirely to Ms. Swift.
Right. And part of in Illinois, for example, any property that you've acquired prior to your marriage is your non-marital property. So if they were getting married here in Illinois, those assets themselves would be safe. However, the appreciation and value of those assets based on her efforts or other income or other businesses that she starts during the marriage, those would be marital assets that the court would divide in the event of a divorce. So in response to Christie's offer as it relates to that, the difference between the parties' income is substantial. Your client makes probably 5 times what my client makes. It's probably 12 times the asset value. And when they get married, I assume they're going to enjoy a very nice lifestyle. Not that they don't now, but it'd probably be much better. So my client's a little bit concerned that in the event of a divorce, if he waives all his rights to those assets and their appreciation, at the end of the day, he's going to come out with less financially. In addition, he won't be able to enjoy the same lifestyle he would have enjoyed if, in fact, they didn't get divorced. So his big concern is he's open to the discussion. However, he wants it to be reasonable and something that's not unconscionable. As we know, the law requires the agreement not to be unconscionable. And in my client's opinion, in this situation, her ability to acquire future income and assets will go for about 35 years. She's got a long career ahead of her, assuming she doesn't get sick or anything of that nature. My client, on the other hand, is in the last few years of his contract with the NFL, what he's really looking at going forward is a substantial reduction in his income because that's the main process upon which he's receiving his income, in addition to some things that he does as far as endorsements, but those will go away too when he retires. So all he's going to be looking at possibly is whatever he could earn going forward as a retired football player. Maybe he can do some NFL podcasting, things of that nature, but his income is going to go down, whereas your client's is most likely going to continue to go up.
And Christy, I know you're ready to respond, but just one question to you, Joe, for representing Travis Kelsey.
Yes.
You mentioned the future potential.
Correct.
What about assets he has today?
Assets that he has today, he would keep as his own as well.
Okay.
So there would be no, especially in my client's situation as it relates to her having any interest in the appreciation of his assets, there may not be much. The assets that he has right now are mostly endorsement related and some slight business relations as well. It's not substantial as it's compared to Ms. Swift. So from that standpoint, there's a big discrepancy.
Okay.
So from Ms. Swift's side of things, I think Mr. Kelsey's realized some benefits already in terms of his endorsements and his popularity just from being within Taylor's world and being exposed to her fan base. I think we've all seen football games appealing to Swifties now in a way that they haven't before. And I think that more companies are certainly interested in Mr. Kelsey since he's teamed up with Ms. Swift. So I think that some of his assets have actually appreciated in value due to his relationship with Ms. Swift. Additionally, I think that we can expect substantially more endorsements in the coming years when the parties are married. The podcasts that you mentioned, those are not chump change. He has $110 million. Your client has a $110 million podcast contract, and I think that we could see him transition. Yes, if he's close to retirement from football, but his career as a broadcaster for one of the major networks could be even more lucrative than the football career itself. So I would argue that our offer is fair. That if Mr. Kelsey's already worth $90 million, I think it's a tough argument to any judge that he's not going to live comfortably with those assets. I think that with a $110 million podcast contract and the potential for a good broadcasting career, I don't think that he can say that his pockets are empty or that they would be after a dissolution.
Yeah, his response in this situation would be, your client's worth $1.6 billion. It's a 3-year contract on that podcast. When that's over and he's out of the NFL, that is not going to continue at least at the same rate. Yeah. As far as the appreciation and value of the assets, he appreciates that now, and he appreciates it during the marriage. But when that marriage is over, the value of those assets are going to be substantially decreased because the interest in Mr. Kelsey, as it relates to being a private person compared to your client as a star, is going to be much less. So his income earning ability is going to be less, his asset values will be less, and you're making my argument for me.
Well, you're walking right into it, according to Joe.
This is just an example.
And that's fine. And that's exactly what we were trying to do.
We can also have the argument, the counter, as it relates to Mr. Kelsey.
Well, and I want to reiterate that as we go through today's edition of Chicago's Legal Latte. We're going to go a few more minutes. But first of all, topics like this for the rest of us in the world, we can always get more information at lavellelaw.com. I always like to plug that. It's a great resource. And you'll find podcast articles by both of these partners at the firm as well as many others. So lavellelaw.com, please take time. It's a very great resource. But we've had some back and forth here now. In this instance, do either of you come to this table with non-negotiables? I mean, are there ever things to say, we're not doing this hard and fast? Yeah. Or is everything...
I personally have a non-negotiable. I think that the parties should agree just for the reason that Joe mentioned. I think this divorce should be an agreed arbitration mediation divorce and that we keep that buttoned up so that there are very few, if any, documents within the public record for the insatiable appetite of our celebrity media. So hopefully we can both agree that will keep this a private divorce.
Absolutely. My client would have no objection to that. As a matter of fact, we'd ask that record be sealed, the court document be sealed. But the one non-negotiable I know my client will have is the engagement ring, which is worth $1 to $5 billion. If this marriage does not continue, he would like to return the engagement ring.
We have no problem with that whatsoever.
Okay.
He can have it.
Just a personal item.
Nice example here, how it starts. How does it end? How long does this go on? Are the parties themselves involved? The attorneys do the work and say, sign this, we're done.
Normally, we don't have the parties sitting in on a discussion like this unless it's absolutely necessary. The attorneys will exchange the information, speak with their clients, have the back and forth as it relates to possible provisions to be included in an agreement. And then if necessary, we can have a meeting of the parties. We like it to be amicable. Most of my experience in doing this is they're fairly amicable. You don't really find too many very contested situations once everybody understands what the law is and what the benefits are to each. Okay. So yes, they can be present, but normally it's not until after the attorneys gather all the information, as Christy indicated, making sure you have all the assets disclosed and income as well. Everybody needs to know what everybody's earning because that's important as well.
Yeah, and Christy, I want to just go back to that because you've talked about the assets, the list of the disclosures. You both mentioned a little bit future income. Mm-hmm. Is it assumed that once the marriage takes place that they sort of are like the rest of us and they have a joint checking account somewhere that everything goes into? Or do they say, no, we're going to keep our stuff separate through the course of the marriage?
Yeah, they can do both.
Yeah, I think it's a point of preference. I mean, just as an attorney, my advice is to keep those things separate.
Okay.
There's never a good way to divide a joint account. Someone's always going to feel like they got the short shrift. My suggestion is that they do not combine their accounts. There's too
Even
much
for the
money
future, even for the new
Yeah,
stuff.
Yeah, and
I mean,
what we
there's-
normally recommend and what most parties will do is they will establish in their agreement perhaps a joint account, which they call the household account, and they will contribute what they believe is appropriate to their contribution towards expenses during the marriage. And then in the event of a divorce, that would be marital property that could be divided, but at least it's controlled. In that situation, you know how much is going in, and you're keeping your other accounts separate. And these agreements can normally provide that any interest that I earn on my current accounts that I keep separate would be my non-marital property, which means in the event of a divorce, I keep it anyway. So those provisions are all set out in our agreements, and they can be quite lengthy and quite intricate as it relates to what we do with those assets and how we keep them in their proper form. But under Illinois law, for example, if you commingle a non-marital asset and with a marital asset, it loses its identity, which means it becomes marital property.
Okay.
We put provisions in the agreements that say, in the event that happens, it's still my non-marital property. So in case there's a mistake, you've prevented it from being used in the case of a divorce. So a prenuptial can prevent all these circumstances that people don't think about when they want to keep their assets separate that could change them to assets that the court could divide in the event of a divorce.
Further comment on that, Chrissy?
No, I think Joe covered it.
Okay. All right. So tell me what each of you would expect these two to walk away from in terms of a premarital agreement. You've talked about some of the things you might propose if you were representing them. And crystal ball, what do you think is going to happen here?
So I think we can expect Ms. Swift to maintain control 100% of her songbook. You know, she had to do all the re-recording to get it back from Scooter Braun or to get a different version than Scooter Braun had.
Right.
I don't think she wants to give it to Mr. Kelsey or any other person beyond herself. I think we can expect that those real estate assets that Mr. Kelsey doesn't live in and that Mr. Kelsey didn't contribute to in any way to remain Ms. Swift's. I think any royalties that are kicked off from her songbook, from her music, from her Eras Tour film, anything like that should remain with her. I would expect that if Mr. Kelsey, who once grabbed a live mic at the White House,
Yes, he did.
if he embarrassed
Very emotional
her,
young man.
I would expect that if he were to do something that sullied her reputation, that some of these generosities to him would probably be contractually waived by him committing infidelity, by him doing something else that's embarrassing to Ms. Swift. And I would expect that the parties would agree to a non-disparagement clause, confidentiality of this agreement, as well as any kind of dissolution proceedings.
And what's important to remember is these agreements do not apply to any child-related situations. So if they have children as a result of the marriage, those would not be included or even discussed in a prenuptial agreement. Those are things that are left for the court's decision. I agree in concept with Christy as far as what the ultimate result would be. I think it would be that Ms. Swift would offer my client a buyout provision as it relates to the length of the marriage, perhaps a dollar figure per year, as she's indicated, as a form of maintenance or alimony, and perhaps a little bit more as far as asset division in the event of a divorce. It could be a dollar amount. But Mr. Kelsey is not going to be destitute by any stretch of the imagination. The question is, what is the lifestyle? Here in Illinois, that's important. So even though regular people would expect a lifestyle to be if you live a very high lifestyle in the event of a divorce, that lifestyle can be maintained. It doesn't matter if you're husband or wife. Whoever's earning more may be on the hook for a larger portion of supporting that other spouse in the event of a divorce. So I think Christy's correct. I think ultimately that's where the agreement would probably go.
All right, before we wrap up, Chrissy, you talked about that list of assets that you start with.
Yes.
Someone comes to you, okay, just one of us regular folks, and they want to do a prenuptial agreement. What do they have to have ready to sit down and talk to you to be their attorney?
Yes. So there is a form that's available on the web. It's used in every county in Illinois. It's called a financial affidavit. It's about 10 pages long. It's a little bit of a pain to fill out, but it asks every question that you could possibly answer with respect to financials. That's a good starting point. Okay. But we would expect, no matter if it's on one of those forms or just something that the person types up, a list of assets. Along with that, we would need the approximate value, right? Current bank statements, current retirement account statements, current appraisals on real estate, valuations on businesses that are owned, or at least, the profit and loss statements from those entities, and a good understanding of what the parties' last 3 tax returns say.
Right. Okay. So that would include the exchange of the actual tax returns themselves. If they're not filing jointly, obviously they're not. So there would be the exchange of that as well as any income information. In addition, any estate documents that might be out there right now as it relates to what their estate's plans are, because that could very much affect what happens regarding the terms of the preparation of the agreement. So all that information needs to be exchanged as part of the process. So yes, that's very important that the parties provide that to their attorneys.
Great. Well, Joe, Christy, thanks for playing along today. This has really been fun and informative. And again, lavellelaw.com is the place you want to go to get some more information, to find out more about these 2 fine attorneys as well as everyone else at Lavelle Law. And if you want to make a phone call, get in touch with them, 847-705-7555, 847-705-7555. We'll be back with a lot more episodes of Chicago's Legal Latte. As always, thank you guys.
Thanks,
Thank
Jim.
you.
Great talking.
Appreciate it.
Thank you all.
Thanks,
Bye.
Joe.